Good evening, everyone, and welcome to today's first Back to School webcast, Understanding Educational Law and How It Applies to Your Child with Psoriatic Disease. My name is Corrine Pettit, and I will be your moderator for tonight's presentation. Before we get started, I'd like to go over a few items so that you know how to participate in today's event. We've taken a screenshot of the attendee interface. You should see something that looks like this on your own computer desktop in the upper right corner. You've joined the presentation listening using your computer speaker system by default. This means that if you can hear music through your computer, you should be able to hear the presentation. If you prefer to join over the telephone, just select Use Telephone in the audio pane and the dial-in information will be displayed. You will have the opportunity to submit questions to today's presenter by typing into the questions pane of the control panel. You may send in your questions at any time during the presentation. We'll collect as many of these and address as many as we can at the end. Before I introduce our first speaker, I'd like to take a moment to tell those of you who may be new to the foundation about who we are, our mission, and what we do. In 2014, the National Psoriasis Foundation developed a new strategic plan which drives everything we do as an organization. To achieve our mission, the following goals were identified. Number 1, accelerate discovery to cure psoriatic disease. Number 2, improve health outcomes. And number 3, achieve goals to help reach our mission, whether it's being involved in an event or becoming a volunteer. By attending today's program, you've already taken a step towards expanding your knowledge about psoriasis and psoriatic arthritis to help manage your disease and to find others who understand what it means to live with psoriatic disease. You can help accelerate efforts towards a cure and greater understanding of the psoriatic disease by participating in the NPF Corona National Psoriasis Patient Registry, which is the largest independent observational registry of psoriasis patients in the U.S. The registry, which involves a network of dermatology clinics, collects and studies patient health information, allowing researchers to compare the safety and efficacy of psoriasis treatments, better understand conditions that are related to psoriasis, and explore the history of the disease. You can also share your experience with researchers about what it means to live with psoriasis and psoriatic arthritis by participating in Citizen Scientists. Answer questions and view your data along with over 4,000 participants. Data is used to help researchers gain a better understanding of the disease. To learn more and participate, visit the websites listed on the screen after today's presentation. We continue to improve health outcomes through our Patient Navigation Center, the world's first personalized support center for people impacted by psoriatic disease. The Foundation's Patient Navigation Center is available to help you find physicians, treatment information, navigating insurance issues, and accessing support through our one-to-one program and more. Contact us at 1-800-723-9166 or visit psoriasis.org/navigation center. To achieve the Foundation's goals as mentioned, please support our mission through donations or by participating in a local Team NPF event near you. On behalf of the National Psoriasis Foundation, thank you for attending today's webinar about educational law and how laws could be applied on behalf of a child with psoriatic disease. Through this webinar, you'll learn about the different types of federal laws, steps for implementing a 504 plan, and hear strategies for working with school staff. Please note, although our Q&A session with all our speakers will occur after the presentation, you're welcome to submit your questions during the presentation at any time. We will respond to questions at the end. Now I'd like to introduce you to our first speaker, Dr. Taylor Richmond. Taylor is an attorney with Miller, Nash, Graham & Dunn based in Portland, Oregon, with a practice focus on educational law. Taylor holds a PhD in multicultural and special education from the University of Washington. While earning his doctorate, Taylor taught graduate and undergraduate educational courses on educational law and equity, multicultural education, and instructional issues in multicultural classrooms. He also coordinated an undergraduate tutoring program that contributes over 10,000 volunteer hours to Seattle Public Schools. His research and scholarship explored equity issues in urban schools, including positive behavior support systems and parental engagement in special education. Taylor is a former youth mentor and public school special education teacher. Welcome, Taylor.
All right, thank you so much, and happy to be here today, and thank you to everyone for joining us. I'm going to try to, there we go, get controls of the PowerPoint. So we're going to dive right in today with a couple of questions of our audience just to get a sense of your experience and your knowledge base, and that can help us tailor our comments today and think about what information might be helpful to you. So the first question we'd like to ask you is, and you should see this as a poll coming up on your screen. We'd like to know what type of school your student attends, if your student attends a public school or a private school. So if you could go ahead and select one of those options on the poll. And then we have a second question, and that question is trying to determine if you have accessed any services for your student in your school, and whether that is services provided as a 504 plan, services under an IEP through the Individuals with Disabilities Education Act, or if you haven't accessed services. And so if you could also take a moment to answer that poll, that would be great. And we'll get the results of those polls in just a moment and make a few comments on them. While those results are tallying up, just going to mention a couple of disclosures and disclaimers. So the first is my legal disclaimer, and just wanting to make sure everyone understands that my comments today are intended to be informational and hopefully helpful, but they're not intended to provide specific legal advice on any of the issues we discussed. The other disclosure I think is important to mention. So I've worn many different hats in education in the past as a special education teacher and researcher. Currently, I work as an attorney, and what I do in that position is I advise and represent school districts, primarily on special education matters, but also on student disability matters more generally. So I mentioned this because I'm certain that affects my perspective on the laws that I'll be talking about today, and how they apply and how they are supposed to apply. And so I want to make sure everyone is aware of that. So looks like we've got some of the results for our polls. First question was whether your students had accessed services, and it looks like 50% of those of you in the audience have access services, and that's been under a 504 plan. And the other 50% have not accessed services, and then nobody has accessed services through an IEP. And if we have the results of our second poll coming up, everyone out there has a student who attends public schools. So some of these laws apply a little bit differently for students in private school, but we'll focus our comments today on students in public school, especially since that's where your students are attending. So thank you very much for answering those polls. I'm going to skip through my disclosures. So today I'm going to be talking about 3 federal laws that relate to students with disabilities in our schools. I'm going to set up the legal framework for these laws, how they apply, the general scope of these laws, and then our other panelists, Michelle and Jamie, are going to discuss with a bit more specificity the types of accommodations and services that might be relevant to students with psoriatic disease, as well as how to go about advocating for those accommodations and services and how to get them in place. The first 2 laws that I'm going to talk about, Section 504 of the Rehabilitation Act, which we just call Section 504, and the Americans with Disabilities Acts, Titles 2 and 3. These laws are civil rights laws. In comparison to the Individuals with Disabilities Education Act, which I'll call and is commonly referred to as the IDEA, that is a law that's focused on the provision of educational services to qualifying students with disabilities. So I think one of the things that you'll pick up on as we go through the discussion today is that the first two laws, Section 504 and the ADA, as civil rights laws, their focus is on preventing discrimination here as it applies to schools, but these laws are more broad than just civil rights laws for schools. But they focus on preventing discrimination, and so they are not particularly prescriptive in terms of their procedures that are required of the school district. They also have a broader scope than the IDEA. The Rehab Act and the ADA apply to many different organizations and entities and apply in many different settings beyond schools and public schools. By comparison, the IDEA only applies to schools, and because it is a law about the provision of educational services, it is highly prescriptive of the procedures required of school districts, things like timelines, processes that school districts need to use, who's required to be on an IEP team, so on and so forth. I'm going to turn first to Section 504 and the ADA. I think that these laws are most likely to be the laws that are relevant to students with psoriatic disease. We'll also spend a few moments at the end talking about the IDEA, but we'll focus on 504 and ADA. For each of the laws, we're going to talk about what types of schools are covered by the laws, the eligibility requirements, and how a determination for eligibility is made, some of the general protections provided by the law. My hope is that you come away from today with a bit more familiarity of these laws, though I'd certainly encourage you to not hesitate if you have questions, to talk with your school, with your teacher. Schools might not be particularly knowledgeable about psoriatic disease, and that's where you come in, and I'm sure that Michelle and Jamie will hit on that in their presentations. But the schools that you work with should be reasonably knowledgeable of the processes that are used that we're going to be discussing today. Also, we've put together a handout. I think it's a 2-page handout on these federal laws, and it's just a little comparison chart. So you can use that as a reference after we get done the presentation today. Quickly going to mention 2 additional things about disability laws. First is that your state might also have state laws, not federal laws, but laws applicable to the state that are relevant to students with disabilities in schools. I think it's most likely that these laws are going to be civil rights or anti-discrimination based laws as opposed to educational services laws. Most of the state laws regarding educational services pretty much follow the IDEA or Section 504. Information about state laws, if there are applicable state laws, is likely to be available on your State Department of Education website, or if they have kind of an information hotline. Additionally, I also think it's worth mentioning that your school district has policies, and these policies likely set forth the relevant procedures for how to go about accessing services and what services are generally available in your school district. And at least for larger school districts, much of this information is available on their website, on their special education department website. So that would be another resource to look at if you're looking for additional information. So we're going to first turn to Section 504 and the ADA. And this is the topics that we're going to cover. First, we're going to talk about coverage. What schools do these laws apply to? We're going to hit the eligibility standards, what is the legal standards to be eligible for protections under 504 or the ADA. We're going to talk about legal requirements of evaluations. Then I'm going to introduce the topic of what's kind of colloquially known as a Section 504 plan, and I think Michelle is likely to discuss with a bit more specificity what a 504 plan might look like for a student with psoriatic disease. We'll talk about how 504 plans are reviewed, the legal requirements for reviewing and updating plans, and then I'll briefly mention a few differences that apply to students with private schools, but again, we're not going to focus on that. So the first question we have is what schools are subject to Section 504 and the ADA? So for 504, this applies to all public schools and any private school that receives federal financial assistance. So this is things like a school lunch program or technology grants and loans from the federal government. This applies to elementary and secondary schools. It also applies to colleges and universities. Section 504 is the educational provisions of Section 504 are overseen by the U.S. Department of Education, and the U.S. DOE makes the regulations that implement this law. And part of the regulations, the parts that we'll be talking about, are specific to elementary and secondary schools. So 504 applies to all public schools and some private schools. The ADA has a couple of different titles, essentially different sections of the ADA. The two that we're going to talk about are Titles 2 and Titles 3. Title 2 applies to any state and local government. So this would also apply to all public school students, colleges, and universities. This is, again, not limited just to schools, but Title II does apply to public schools. Title III applies to places of public accommodation, and this in the statute specifically applies to private elementary, secondary, and post-secondary schools. The U.S. Department of Justice, not the U.S. Department of Education, but the U.S. Department of Justice oversees the ADA and creates the regulations for implementing Title II and Title III. And I'll note, since everyone who joined us for the poll has a student in public school, if you are a student in public school, you're duly covered under Section 504 and Title II of the ADA. In the ADA implementing regulations, there's a reference to Section 504, and essentially that reference says that the ADA defers to 504, which is a bit more specific with respect to the requirements of public schools. So typically in schools you're going to hear references to 504, and I think it's less likely that you'll hear a reference to ADA. A student who qualifies, and we'll talk about what that means in a minute, but a student who qualifies under ADA also qualifies under 504, and services are typically delivered under 504. One thing to note about ADA, there is a religious entity exemption. So if your student attends a private religious school, your student might not be covered by either Section 504 or the ADA. In this case, there's the possibility, depending on what state you're in, that there are some state law protections that are similar to some of the protections provided by 504 or ADA, but neither of these laws apply to private religious schools. So, what protections do these laws provide? Both of them, Section 504 and ADA, provide anti-discrimination provisions. Essentially, what these laws prohibit is exclusion from participation in school or the denial of benefits, the denial of any educational benefits on the basis of disability. So these are big concepts. This is not, Section 504 and ADA are not intended to kind of police minor issues or disagreements with school districts, but are set up to prevent actual or constructive exclusion of students, that is, not allowing them to have meaningful access to their education as a result of their disability. Both laws also have anti-retaliation provisions, and in this context, what those provisions relate to is a prohibition on taking any adverse action against a student or a parent for attempting to assert a right under one of these laws. So attempting to advocate for your student. The anti-retaliation provisions prohibit a school district from taking any action against your student on account of your advocacy. For public school students, 504 also has an element for some students who qualify under Section 504, and we'll explain which students those are. But for some students, they're also entitled to a free, appropriate public education. The free, appropriate public education does not apply to students in private school, though private school students are entitled to a prohibition against exclusion if an appropriate education can be provided with minor adjustments to the school's services and programs. So, what a minor adjustment, to think about what might constitute a minor adjustment. These are adjustments or accommodations that could be provided without significant expense or what's referred to as a fundamental alteration of the educational program. So we've discussed what schools are covered by our laws, by the federal laws we're discussing today, and what protections those laws offer. They offer anti-discrimination and, in some cases, the provision of free, appropriate public education. Now let's look at what students are protected by these laws. This is going to be a two-step process. The first step for Section 504 is making a disability determination. Oftentimes this is referred to as eligibility, but either eligibility or disability determination. So we look to what is the legal definition of disability under Section 504 and ADA, and they use the same definition. The definition is a disability is a physical or mental impairment that substantially limits one or more of the major life activities. So we'll break that down a little bit. A physical or mental impairment is any physiological condition, a speech and hearing impairment, a learning disability, ADHD, psoriatic disease, etc. So any physical or mental impairment that substantially limits, and substantially limits is defined as, well, it doesn't have a specific definition, but it is intended to be construed broadly, and the law says broadly in favor of expansive coverage. This is not intended to be a demanding standard to meet. So it's a physical or mental impairment that substantially limits one or more of the major life activities, and Section 504 and ADA provide a very long and non-exhaustive list of what major life activities include, things such as caring for oneself, performing manual tasks, eating, sleeping, walking, sitting, concentrating, thinking, interacting with others. So it is quite a long list, and you can see it's pretty encompassing. So the first step of the eligibility process is making a disability determination. And again, I'll just repeat that this step is not intended to be a particularly difficult particularly difficult criteria to meet. It's intended to be broadly applicable, so that students with disabilities are covered under some of the protections of 504 and ADA. And sorry, I'm trying to move my slide to the next screen. There we go. So in terms of making the determination process, I'm going to just quickly set up the legal framework for this, and then Michelle and Jamie will provide some more details there. There's essentially two ways to initiate the process. First is a parent can initiate the process, and I think Michelle is going to discuss what that might look like. The second way is for a school to recommend an evaluation occurs. The school needs to do this when it knows that a student has a disability or when it has a reason to suspect that the student has a disability. So a parent can request, the school district, typically when a parent makes a request, the school district will conduct an evaluation, although it is not always obligated to. There's not a specific time frame in which the school district needs to conduct the evaluation, but the Office for Civil Rights says that the school district needs to respond in a timely manner, and oftentimes courts and the Office for Civil Rights looks to the IDEA, which says that evaluation should happen in 60 days. So a very frequent question is whether a documentation of a disability is required in order to be found eligible under Section 504 of the ADA. And the answer to that is that it is not necessarily required, but school districts are permitted to have policies requiring medical documentation, though if they do have a policy for this, the school district is responsible for arranging and paying for a diagnosis if the student doesn't already have one. The determination of whether a student meets that definition of disability that we just talked about is made by a group of people. Under Section 504 and ADA, this has to be a group of people that is knowledgeable about the about the child, So that's at least two people. Typically, it includes the parents, although the law does not necessarily require that. Though parents do have a right to examine all records that are used for making an eligibility determination. If a student is found to have a disability under these laws, they are entitled to the anti-discrimination protections of Section 504 and ADA. The second step of the disability determination process is to determine whether the student qualifies for services, and this is known as the Section 504 plan. And again, I think later in the presentation we're going to talk about what type of services a student might be eligible for, or under Section 504 or ADA. But at this point, we're just going to mention that this is the second step of the disability determination process. At this step, the team that makes this determination can consider whether the student has other mitigating, whether there are other mitigating measures being used, such as use of medicine or outside therapies, in making a determination whether the student actually needs services provided by school to access their, to meaningfully access education. In terms of what the team needs to consider when making a determination of services, 504 requires schools to establish their own standards and procedures for evaluation and to use them. They have to use tests and other evaluation materials that are validated and that are tailored to the specific areas of educational need for the student, and they need to draw upon information from a variety of sources. So all relevant information known to the school, and that includes information provided by parents. And at the end of this determination, the school needs to document what information it considered and what determination it made, whether the student does or does not qualify for services under 504 or ADA. And that needs to be documented and provided to parents. If a student does need services, if the determination is made that the student needs services, then they are entitled to a free appropriate public education. So just a few comments on what a Section 504 plan might look like. Most schools put Section 504 plans into writing, although this is not a requirement of 504, though again, typically schools do this. Before Section 504 plan is implemented, parents need to be notified, and Section 504 plans can and should pertain to academics, non-academic activities, and extracurricular activities if a student needs services in those areas. One thing to note, if a student qualifies under Section 504 but needs special education, then the school is going to go through the IDEA eligibility procedures and implement an IEP, so services will be delivered through an IEP, not through a Section 504 plan. Section 504 does not have very specific requirements for reevaluating whether a student qualifies for service or whether a student is determined to have a disability or whether a student qualifies for services. It just requires that there's periodic reevaluation. It doesn't give a specific time frame for that. Many schools reevaluate every year, particularly for students who have a Section 504 plan that is frequently kind of revisited and, if necessary, updated on a yearly basis, though there's not a specific requirement of that. Some school districts default to the standard under the IDEA, which requires reevaluation every 3 years. And so I'm just going to throw up a couple of notes on private school students, just so you can see some of the differences in terms of what is provided to private school students versus public school students. Under 504, private school students receive minor adjustments to the educational program, and under Title III, schools need to provide accommodations so long as those accommodations aren't fundamental alterations or present an undue burden. Often that's an undue financial burden on the school, and typically that depends on the size and resources available to the school district. So I'm going a little bit over my time here, but I would like to quickly touch base about the IDEA, since that can be relevant to students, particularly if students have another disability as well as having psoriatic disease. The IDEA applies to children with disabilities from birth through high school graduation or age 21. There's specific procedures and services for school-age children, and that's what we'll talk about, and in particular, students who attend public schools. As I mentioned earlier, IDEA is very heavy on procedure, so today I'd just like to give you a general sense of how the process works, but not go into much detail about the process. The big picture idea with IDEA is that it provides special education to students. So special education is instruction that is specially designed, that's been developed to meet a student's individual needs. So this is a more intensive intervention or change to the educational environment or instruction than is provided under Section 504 or the ADA. Also noteworthy is that IDEA covers less students. There's a smaller subset of students qualify for IDEA than qualify for 504. IDEA, like Section 504, has a two-step eligibility criteria. At the first step, this will be familiar, there's a determination whether a student has a disability. There are 13 categories of disability eligibility under IDEA. One of those categories, the one I think most relevant to our discussion today, is other health impairment. So the definition of other health impairment is a student with limited strength, vitality, or alertness that results, limited strength, vitality, or alertness, which is due to a chronic or acute health problem and adversely affects the child's educational performance. As with Section 504, there's not a requirement of a diagnosis of a disability, though that's information that's considered by the school district. So the second step of IDEA eligibility is, and this again will be familiar, a determination that the student needs special education and related services. Here too, like Section 504, a student can be referred for an evaluation by a parent or by a school district, and the school district needs to request an evaluation when they suspect that a student has a disability. The school district must respond promptly to a referral for services, and what they need to respond promptly with is making a determination whether or not to evaluate the student. This decision includes a discussion with the parent. It can be at a meeting or it can be over the phone. It doesn't have to be at an in-person meeting, though often it is, but it does have to include the parent and at least two professionals from the school district. If the school district determines that they're not going to make an evaluation, then they send the parents notice of that on a form that's called a prior written notice. If the school district decides that they are going to evaluate the student for special education, then they'll set up an evaluation planning meeting and they'll invite the parent to come to that meeting. At that meeting, generally what happens is there's a review of all existing data on the student, how they're doing in school. This might be existing assessments or teacher observations, as well as input from parents. And the team will identify what additional information or data, if any, is necessary for making an eligibility determination and creating an IEP. The evaluation of a student must include a variety of assessment tools and strategies. As with 504, it has to be tailored to the specific areas of educational need for the student. And for IDEA, it has to be a comprehensive evaluation, that is, an evaluation that assesses all areas of suspected need. IDEA requires written consent from parents to conduct an evaluation, and once that written consent is provided, the school has 60 days to complete its evaluation, although that timeline can be modified by state law. So, for example, here in Oregon, school districts have 60 school days, not 60 calendar days, to conduct an evaluation. After the evaluation is conducted, the team gets back together and discusses whether the student is eligible, whether the student needs special education. And again, this determination is documented in a prior written notice that is provided to parents, and parents have rights to review all of the assessment materials that are that the team has and uses to make its decision. If a student is found to be eligible for special education, the parent has to provide written consent before the school district can initiate the delivery of special education services, and at any point, a parent can revoke their consent for special education services. Once consent is provided to services, the school district has 30 days to hold an IEP, an initial IEP meeting. I'll quickly mention who's on this team. The IEP team consists of a parent, a regular education teacher, a general education teacher, a special education teacher, a representative from the school district, often that's a principal or school counselor, and one of those individuals needs to be a person who can interpret instructional implications of the evaluation materials. The parent is allowed to bring anyone else that they want to an IEP meeting, and if it's appropriate, the child attends the IEP meeting. There are pretty specific requirements regarding parental participation on the IEP team and in IEP meetings. These include not just inviting parents and figuring out ways for them to be part of the meeting, but a requirement that parents have an opportunity to meaningfully participate in the IEP meeting. I'm not going to go over all of the contents of an IEP, but just one thing to note is that the IEP kind of lays out the special education plan for a student, including very specifically identifying what special education services, what related services, what accommodations and modifications the student will receive. I'm trying to get my slide to go to the next screen. And final comments here, an IEP gets reviewed annually, or it can be reviewed more often if any member of the IEP team calls for an IEP review. The evaluation, the reevaluation of eligibility runs on a 3-year cycle, or again, if the team determines that more frequently is appropriate. And then a final note on students in private schools. Your local school district will conduct an evaluation to determine eligibility, even if a student attends a private school, but services, if a student is eligible, services to students attending private schools are offered through an individual service plan, which has some similarities to an IEP, but entitles students only to equitable services, not to a free appropriate public education. And that is the end of my comments on the 3 federal laws applicable to students with disabilities in schools.
Great. Well, thank you so much, Taylor, for sharing with us. We're going to move on to our next presenter, and I'd like to introduce you to our second speaker, Dr. Michelle Harmala. Dr. Harmala is an associate professor and graduate director at Madani University in the College of Education, where she leads the university's doctoral program in leadership and innovation. Prior to joining Madani University in August 2017, Michelle served as the superintendent for Wayne Westland Community Schools, where she fostered organizational growth and student learning through a culture of collaboration and respect. She has also served as a special education director, assisting individual school districts with development of educational services in the areas of special education, transition services, and career technical education for students with disabilities. Dr. Harmala holds certifications as a superintendent, central office administrator, special education director, transition specialist, special education teacher, and teacher of mathematics. Welcome, Michelle.
Thank you very much. I'm happy to be here. I'd like to share my views in light of a real focus I have on partnership. And I think that that's a really important thing to say up front, because getting the work done on behalf of a child is really about a partnership. And Corinne, I'm just going to mention that I haven't been able to move my slides forward, so maybe you can assist with that. Thank you so much. All right, so ultimately the partnership we're talking about is required because everybody working with the child has different information and knowledge about what's going on. And if we start with the view of a positive and a productive partnership, we're less likely to head in adversarial directions, whether that's the school personnel or the parent. And partnerships, it's really important to understand, are not without problems. So I believe there are really 2 important things to think about, and that is that there will be problems to solve and problems to resolve together, and that clear and civil communication is really the most effective way to solve those problems. So for the sake of the child's learning and growth, I thought the quote by Chief Sitting Bull was appropriate. Let us put our minds together and see what life we can make for our children. So I'm going to speak more to how we collaborate together and what that looks like when we do it well for the sake of a child. Okay, so Taylor talked in detail about Section 504, so I'm not going to go over that. And he also mentioned that IDEA is an option if a student needs a more intensive level of support. But what I want to really focus on is that The provisions for Section 504 for most school districts, they're going to mirror some of the policies and procedures they may have in place for IDEA. And most school districts will do that because it makes their work a little more simplistic. They wouldn't have two systems running per se. They would have one way of going about the work, although under Section 504, as Taylor mentioned, it's not nearly as prescriptive as the special education law IDEA is. So he mentioned a couple of the principles as demonstrated in this slide: the referral process or requesting consideration for eligibility, the determination, then really developing the plan. The rubber hits the road at implementing the plan and also at monitoring that plan. And again, even though it's not as prescriptive, the school districts I've worked with and the counties I've worked in, and I'm here in Michigan, we generally follow similar procedures to IDEA just because it makes it, the consistency makes it easier for staff to follow, and they would be more strict than just setting up a general rule. IDEA is very prescriptive, so timelines are all there, and many school districts use those, again, although they're not required to. In requesting consideration, you heard some of this already, but I can't mention it strongly enough. Inform people verbally and in writing, and request things verbally and in writing. Educators are really busy people, and schools are tremendously busy places. You know the size of your own child's school, but schools can be anywhere from, say, 200 kids to over 1,000. And given the size or the busyness of any given day, even with the best intentions, sometimes things slip out of people's minds or off their plate. So it's not being overly difficult to put things in writing. You're not trying to be demanding by doing it. I think as an educator, I've always found it to be helpful. That way I have your thinking and I don't lose it, whereas something could slip out of my mind. Also, be real specific about what your concerns are. You might be saying, hey, I want you to be aware. You might be saying, hey, I want my child assessed. So be as specific as you can be in whatever you put in writing. And then I always recommend that in that request or informing, if some follow-up is needed, ask specifically who will follow up with you and by when. Most parents start with their child's teacher, and that's great. But if your child's teacher is not a person who's tremendously informed about a 504 plan or doesn't know the timelines in mind and heart and would have to look them up, then you may have to allow them the time to do that. But find out if that teacher's going to follow up with you or whether it would be somebody else, and find out by when they will do that. The request for any formal evaluation of your child to determine a disability, regardless of whether it is under 504 or IDEA, although it's not required in the law, I really strongly recommend you put that in writing and put the date on which you give it to the school so that you remember and they remember when this whole process started. It's important to note that as a parent, you should be very active in the process. Since psoriatic disease is a health-related issue, again, as Taylor mentioned, educators might not have specific knowledge of psoriatic disease, and they need you to help them understand both the disease and how it impacts your child, as well as the supports your child might need, because you may be doing some things at home that could translate into the school setting. So in that evaluation process, it's important to bring out information, use existing information that you have as a parent. You might ask the school what information they have about how well your child is functioning. But as was talked about, sometimes evaluation requires new information. So you might do some assessments or gather data from other sources. And again, it's really important. Schools want to know that you are giving your consent for them to do these evaluations, whether it's a signed process under IDEA or whether it's more general, we want to know you're a partner in this and that you're agreeing to the kinds of things that are going to be done to make a determination of eligibility. It's no different than when you're in the process of making that decision, sitting at the table, kind of trying to determine, or over the phone if you're doing it over the phone. Be upfront, share information. The more you know, the more helpful it is to the school. You can ask schools for their reports and evaluation information, ask them for a copy. I always recommend getting it ahead of time if you're the kind of person who needs to review it, process it, and jot your questions down. There's no harm in that. I think if you're under particular timelines, you might want to let the school know ahead of time that that's your preferred way of reviewing the information so that they can make everything happen in the timeliness that it should. Jot your questions down, ask all your questions. No questions are too silly. We want to know what is on your mind. And again, throughout the process, if you continue to give your consent to the things that are going on, that's helpful. If there's something concerning, then certainly you would share that and not consent to do something that you didn't think was right or appropriate for your child. The next slide. Let's see if we can, Corrine, if you can help, I'll take your help on that. See if we can get there. All right, the content, thank you. The content of a 504 plan, once eligibility is determined, again, as Taylor mentioned, it's not required that the plan be written down. However, as a school person, I really would be hard pressed to understand how a plan can be implemented if it's only in people's memories, because there are lots of students and lots of individual cases. And my experience has been plans committed to paper make it easier for everybody to know what's going on. So that would be my encouragement. And in a partnership, understand that each person at the table helping to make decisions about what would be included in the plan has their own perspective. And while dysfunction and difficulty can occur, they're generally not the norm. But I've seen many parts of the process break down, but none more than the plan development stage. And generally that breakdown occurs because of expectations that both parties have, but they may or may not be articulating them or communicating them with clarity. So we want to make sure that if you have thoughts about what you expect to have happen for your child, you share them, and the school will also share what they believe they can do and how they can do it. And it's sort of a give and take conversation to try and get to the decisions that'll finally be made to provide service for the child. But again, seeking first to understand each party's perspective and stay in the dialogue long enough to understand. And there might be some really good questions you could ask along the way. Help me to understand that. Could you tell me what that might look like in action for my child during the school day? Or simply, can you say that another way? I'm not sure I understood it. Often school people talk in jargon. They're comfortable with their school language, if you will, but they forget that they're throwing around acronyms or other school-based terminology that generally those outside of our day-to-day school work may not be as familiar with. So again, the content would be specific accommodation supports and services. We'll go into that in a second with more detail. Press for when those services are needed, because different services may be needed at different times throughout a school day or a school year. Who will make sure those services are provided, or who will provide them? And then who's responsible for the implementation of that plan and the follow-up? Those are really good components to put in a plan. I always say it like this: the plan is really that roadmap that says, how is your child doing now? What is it we want your child to know and be able to do differently by the end of the year? And how are we going to help them to get there? And then who's going to be responsible for making sure that happens? So that's generally the content. And again, I would press for it to be written down. It helps everybody. So accommodations are generally the support that are going to be provided. Some supports might be needed for a longer period of time. You can't see me right now, but you might have noticed in my picture I wear glasses. My glasses aren't going away anytime soon, so rethinking that or thinking about reducing my need for them would really not be appropriate. But there are other accommodations we provide that may only be needed for a specific period of time or a particular phase in somebody's life. So a young child might need more support than a student who's in high school or a young adult who happens to be in college. So we want to think about accommodations according to the need of the child in a given time and in a given environment. And certainly if they need less accommodation over time, that's fine. And if they need more accommodation over time, that's fine. Here are some types of accommodations. There might be an accommodation in how information is presented to a child, whether that's through textbooks or lectures or other kinds of presentations. There are response ways of accommodating a child. So how is the child going to respond to you or to the teacher? If writing is particularly difficult, could somebody take dictation? Could things be recorded and then turned in, as in like a digital recording, maybe on a phone or on a computer? They may need extra time. Sometimes assistive technology, as simple as a pencil grip, can make a difference for a student. Think about the setting in which your child is. For example, if they have a big school and they have to go to lockers between classes, is there a need for them to not carry all their heavy books in a backpack all day? So where should that locker be located? If they're in a PE class and there's particular concern about privacy issues, you can talk about how to accommodate that. Taylor mentioned, think about those non-academic times and the extracurricular times. Think about things like, does the child need extra passing time, particularly if you're in high school and the high school is very large and there's only 5 minutes between classes. You may have to go from one end to the next. Is there a need to add additional time? If the weather is inclement here in Michigan, we can be 80 degrees today, and over the weekend we're going to be in the 30s. So does indoor recess make sense for certain types of weather conditions? Are there different kinds of activities one might have to engage in a gym class, for example? And then there may be this category called other, for example. Does your child need a break from sitting for long periods of time? And if so, what accommodation could be made for that? Or medication administration may be another one. Most schools require medications to be administered through personnel in either an office or a nurse, and there's whole kind of documentation process for that. Sometimes in high school, kids want to administer their own medication. So certainly those are things you should discuss and talk about within the 504 planning process and get that documented. And then again, as your child grows up, you may want to keep in mind that a 504 plan may be appropriate in a college. At the university where I teach, we have students who have accommodation plans. Just remember that by the time your child gets to college, they're generally an adult by definition. And when that occurs, then they really become their own advocate for these kinds of services. So I think it's really important to include your child in the process, of course, age appropriate, but as soon as you feel like they can be a part of both the planning and the identification of accommodations that work and requesting them during the school day, it's a good idea to include them and teach them to advocate for themselves. So we're going to take a look at implementing the plan. I think the most important piece of this is anybody who has a need to know must have access to knowing what's in that plan and the related information. So if a person is going to interact with your child during the day, say your child changes classes, but that person was not at the meeting in which the plan was developed, we just want to make sure they have access to it and fully understand it, so that they know what to do to support your child. I already mentioned helping your child as age appropriate to advocate for themselves and to self-regulate. That can be taught over time. And then again, be very clear with the communication about who's doing what by when, where, how, and sometimes even a why. I know with accommodations, sometimes there's the battle that has to be fought around, well, this seems like it's unfair. That's not the right question. Really, we give people what they need. And so if somebody doesn't understand the accommodation, sometimes helping them to know the why is really helpful, whether that's an educator, whether that's a child, or sometimes why a school personnel may be suggesting a particular accommodation for a parent to consider. And again, the less jargon we use and the more clear we are in our communication, again, the less issues we'll have day to day. And it's a good time, again, to insert some of those questions like, help me to understand more about whatever the particular situation is, or tell me what you were thinking. Could you describe what that would look like in the school? And vice versa. Again, monitoring the plan on the right-hand side of the slide, knowing who's responsible for the day-to-day work, but also having broader information about who's in charge of 504 within the district. Agreeing on what will be communicated to whom and how often. One of the things that I've seen happen a lot is expectation around regular communication. And it might be a parent says, can you communicate with me regularly about how my child is doing? The problem with a term like regularly is everybody has their own definition in their own mind. So if a teacher thinks regularly is once a week and you were hoping for every day, while you didn't talk about it, you assume that general terminology regular gets you to that point. But I would encourage you to continue talking until you come to agreement on what seems about right. Again, have ways to share emergency information if something unusual happens to your child, or if the school sees something during the day they want to report to you and they think it's more of an unexpected issue, an emergency issue, just know ways that you can reach each other. Involve your child to the degree appropriate. And as Taylor mentioned, review the plan regularly, rewrite it if you need to. It's not as stringent as the IDEA that you must do it annually, but certainly if things change, bring that to the attention of the school. It's a lot easier to address it if we know that something has changed. And on the 504 plan, we hope nothing goes wrong, and usually things don't, but occasionally troubles do arise, and it might be necessary for you to look to the school district's policies or the superiors to support whatever difficulty is going on. Ask for the district's policy of non-discrimination. You could ask for their grievance procedure. You could contact the school district Section 504 coordinator, and in every school district, this may be a different person, and some school districts may not have somebody with that unique role. It may be a role combined with other roles. And if you don't know where to start, you can always call the office of the superintendent and you can say, hey, this is the struggle I'm having. Who can help me with this? Also, your child's principal in their particular building may be a good starting point as well, because they may not be the coordinator for 504, but they sure may know who it is in the district. And then I strongly encourage everybody, both educators and parents, as well as students, to presume positive intent when things go wrong, but also know your rights for the sake of your child. Very important. And then the slide here is just one that I find to be a tremendous resource, parentcenterhub.org. They have a lot of information on an array of different topics related to supporting children with disabilities within the school settings. And you may find many other useful documents here that would be worth examining. So it's there for you simply as a reference. And then I would end with the thought, and I'm sure here Henry Ford was thinking about his assembly lines way back when, but I think it applies that really the partnership of serving a child is coming together is only the beginning, but keeping together is progress, and working together is success. So thank you for letting me share some views on that.
Great. What a wonderful quote to end on. Thank you so much, Michelle. And now we're going to move on to our final presenter, Jamie Moy. Jamie is a parent of a child with psoriatic disease who also serves as chair of the National Psoriasis Foundation's Youth Services Committee. Jamie took on this role, seeing a need to help fulfill resources on behalf of youth with psoriatic disease and their parents. With her guidance, the youth website Our Spot was formed. In addition to taking an active role in development of resources for youth, Jamie also serves on the Foundation's Outreach Committee and is an active community ambassador. She is a compassionate, engaged, and innovative volunteer who, as a result of all her efforts, won the Foundation's Volunteer of the Year Award in 2017. Most importantly, you will hear Jamie's experience as a parent and as she shares her story and offers tips to help all of you as parents. Welcome, Jamie.
Hi, thank you, everybody. Thank you for being on this webcast tonight. You've already heard so much informative information. I'm just a mom, and I can only provide perspective on what we went through. My son Andy was diagnosed at 4 with psoriasis, and at age 5 with psoriatic arthritis. We started a 504 plan when he was in 2nd grade. So basically, you've already heard some great information from the previous speakers. So I'll try not to duplicate that information. But I did want to just provide you with some firsthand experience and some tips and tricks that I found going through the 504 plan from elementary school to middle school to high school. And hopefully some of those you will be able to use as well. So I know half of you on the call don't have a 504 plan in place. What I'm going to talk about is the 504 plan, not the IEP that is quite possible to get as well. But in our school district, my son didn't qualify for any additional services. So I can only speak to what we went through setting up a 504 plan. And I know half of you don't have any sort of plan in place. So I would just caution you about that, because you don't really know what the future holds. You might have a great teacher this year who is willing to work with you one-on-one and your student, and whatever your child needs, the teacher is wonderful and is just going to just allow it to happen. That's fabulous. However, we know that teachers change from year to year, principals change, as well as other staff members. So just a 504 plan will follow your child from every grade. And then also into college. So having that in place and having it in place early will just help ensure that every year your child gets what he or she needs in the classroom to be successful. So you should also understand the relevant federal and state laws that can apply to your child. So what was mentioned before was that in some school districts, instead of having a 60-day policy deadline, it's an actual 60 school day policy deadline. The same was true from when we set ours up, and I wasn't aware of that when we set it up, so I was counting every single day, including weekends and school days that the children didn't attend. So there was miscommunication because I was not fully aware of the deadlines and the policies and what that actually meant. So having that in mind when you go into it will really help you keep a better timeline and schedule of when you should expect to see a meeting and plans be put in place. So one of the ways that you can help your child is if they're in elementary school, you can ask them to take you through a day of what they go through. As a second grader, my son couldn't tell me everything that he needed in school to be successful. He couldn't tell me that, circle time on the floor hurt his hips. But when I asked him to take me through a day, I was able to ask him, does sitting on the floor for a long time, does that hurt you? Then he was able to say yes. It triggered, his memory throughout the day. When they're that young, it's hard to know. When they get into middle school and high school, of course, they're more aware of what they need and they're able to communicate that to you more. And speaking of communication, you should talk with the school nurse, principal, of course, your children's teachers and other school staff, not only to educate them about psoriasis and psoriatic arthritis, but also about what your child needs specifically to make it through the school day in a great way. So some tips that you can do, as was already mentioned, make sure you know who your point person is. When we set up Andy's 504 in second grade, there really wasn't a point person in his school because no one else in his elementary school had a 504 plan. So they kind of had to find somebody and designate her to be that person. So that was a rough start for everybody involved. It was a learning curve for everyone. Also, when you do find out who that point person is, find out how they like to be contacted. I thought emails would probably be the best way to communicate. As it turned out, that our point person liked to have phone calls instead. So again, that disconnect really made things more aggravating because I wasn't communicating well and she was not returning my messages well. So the more that you can all be on the same page to start with, the easier it'll be. And then keep a calendar of certain deadlines coming up and for when the school is responsible for meeting them so that you can be on top of it in case something does fall through the cracks. You're able to follow up and say, hey, by the way, where are we in the process and do you need anything else from me at this point? As was already mentioned, go in assuming everybody is there to help you. Don't think the worst and that they've dropped the ball. It could very well just be that they're waiting for somebody else to get back with them to be able to relay that information to you. And then I already talked about some of this, so we'll move to the next slide. So here's some examples of elementary school accommodations that Andy had. At that time, it was mostly his psoriatic arthritis that was causing the trouble. However, he does tend to flare even to this day in October and November with a flare of psoriasis and psoriatic arthritis. So those can get bad around fall time for him. So that's important to remember as well. And that was even back in elementary school. So grippers or felt tip pens for schoolwork and homework. In elementary school, when Andy's now 20, so back in the day, having a laptop or cell phones to do dictation was not really an option. So having a teacher or us as parents dictate the work, that was a combination that we had. Obviously, technology has advanced so much that that would probably be updated in what you need. And then, of course, extra time and a second set of books helped so that he didn't have to carry home his books every night. That got to be too much. on a little kid with backpack. Some of those books are pretty thick, even in 5th grade. So having a set for school and a set for home, that helped a lot. And then another thing is being able to get up every 30 minutes and move about the classroom, and trying to make it so that it's not obvious that he needs accommodations. No child wants to stand out or look different. So some of the options that the teacher came up with was that Andy could collect homework, or that he could pass out flyers at the end of the day, or certain things like that. So it didn't really draw attention to the fact that he needed to get up and move, because a lot of times when he would do that, many of the other kids decided they needed to get up and move too. In one of Andy's classes, she actually decided to have all of the kids stand up and stretch, and that was beneficial for everybody. Some of these other things we've already gone through, but another thing is not to be penalized for not attending classes, for having tardies or absences because of doctor's appointments or light treatments, or if the medication is making them feel nauseated or sick. And of course, those accommodations would go throughout his whole elementary school to high school career. One of the other things that we needed to do was we specifically asked for a bus stop at the end of our house. Otherwise, he would have had to walk a mile to school. And in Michigan, when it's cold out and it's icy, that makes it really hard, especially in the mornings when he was stiff. So they did add a bus stop at the end of our driveway, and all the other kids in the neighborhood appreciated that very much. So one accommodation for your child can actually benefit other students as well, so don't be afraid to ask. We also asked that he have gym class at the end of the school day so that he didn't necessarily have to shower. He could just come home and be able to shower at home and feel more comfortable, especially with psoriasis. And then in high school, I think it's coming. I'm having trouble advancing. Corrine, are you able to advance the next screen, please?
Yeah, we're working on that. Just a second here.
Okay, thank you. Okay, so some suggestions for when the process isn't working. Make sure you pick your battles and be ready to compromise, but that doesn't mean that you compromise your child's health. Just stand your ground, but know, like in middle school, they didn't have an elevator. They had stairs, and Andy would have to go up and down the stairs every day. Asking the school to put an elevator in was never going to happen. However, we were able to get all of his classes on the first floor, so he wouldn't have to climb the stairs. So that was a way that we could make it work. Always update the plan if you need to. If something comes up, if there's a change in your child's health or a change in classes, that something new has come up, be sure to communicate that and update the plan when needed. And always be polite and respectful to the school staff. They're there to help your child. You may not always see eye to eye, but just know that they do want to help your child. And then also know what the appeal processes are and when you can make those appeals ready, and make sure you have the documentation. You don't want to go into hearing without the necessary documentation and have everything be pushed back even more. And as I said earlier, this is your chance to also educate the educators about psoriatic disease. They may never have heard of psoriasis or psoriatic arthritis or have come across any students with those diseases. So now is your chance to educate them. And be sure to follow up with the school staff and your point person to know where they are in the process and if they need anything else from you. And then always look ahead to the next year. I found that asking in March or April to have a 504 plan meeting to get accommodations for the next year that always seemed to be about a good time. If it was in May or June, that was too close to the end of the school year. And, or if it was in September, the school staff and teachers were a little crazy getting everything ready to start the year or wrapped up. So be mindful of when it works into their schedule as well. And that's all. Thank you.
Great. Thank you so much, Jamie, for sharing your expertise with us. And to all of our presenters, a big thank you. You guys covered everything so thoroughly that we didn't have any questions come through. So we'll move through the Q&A session. If you do have any other questions, if you're listening to this after the fact and have some questions about what is shared today, you can contact our Navigation Center by phone, email, live chat, or Skype. And once you leave today's webinar, you will receive a survey on the presentation. We'd appreciate it if you would complete that and provide your feedback. For resources specific to youth and you as a parent, please visit our spot at psoriasis.org/rspot. Resources include age-appropriate information up to age 18, personal stories, and after tonight, a link to a recording of tonight's webinar. And as a reminder, don't miss next week's Back to School webcast, Coping with Psoriatic Disease, Helping Your Child Navigate Through School and Beyond. Finally, I just wanted to mention you can access our complete webcast archive by visiting psoriasis.org/webcast. Thank you everyone for joining us tonight, and I hope you have a lovely evening.